Good morning and welcome to Gough Square Live. I am Alison Lambert and I am joined by Brady. We are both barristers at Gough Square Chambers, specialising in consumer and trading standards law. Today we are going to be talking about obtaining evidence from abroad, serving defendants overseas, proceeding against the right defendant, and consent, connivance and neglect. It is a real pick and mix of those topics for those involved in regulatory prosecutions. Over to you, Jack.
Let's consider a scenario. A trading standards team is prosecuting a company called Green Future Solutions Limited under Section 2 of the Fraud Act 2006 for fraudulently obtaining environmental grants from a local authority. Green Future Solutions claims that it imports and installs high-efficiency solar batteries from the Netherlands. When applying for a sustainable small business grant, it submitted invoices and compliance certificates from a Dutch company, Soltec Power Europe, that Green says produces the batteries, and Green was awarded £50,000. The prosecution alleged that no batteries were installed and that the paperwork used to apply for the grant was forged. Critical to the prosecution's case, therefore, is obtaining a statement from Soltec Power Europe confirming that the company did not issue the certificates or invoices and that it had no commercial relationship with Green Future Solutions. Soltec isn't cooperating, however, so how does the prosecution obtain that evidence from abroad? Similarly, to use the same scenario, the defendant claims it signed a contract with a Dutch sales agent whom it pays directly, and that the agent has copies of the original invoices and compliance certificates. The agent refuses to engage though, so how does the defence go about obtaining the agent's bank records or those documents when they are in the Netherlands? The answers to those questions lie in mutual legal assistance. But what is it and how does it work? Well, mutual legal assistance is the method by which states cooperate to obtain assistance in investigations or in the prosecution of criminal offences, and in the freezing and confiscation of the proceeds of crime. Of course, due to the increasingly global nature of criminal activity, it can be an important tool in criminal proceedings. In the first instance, those seeking assistance will want to satisfy themselves that the relevant evidence cannot be obtained voluntarily. I say that because voluntarily obtaining evidence is certainly a less burdensome approach, but it's not always possible, as in our mock case of Green Future Solutions Limited. Where evidence cannot be obtained voluntarily, a formal request for mutual legal assistance can be made under Section 7 to 9 of the Crime International Cooperation Act 2003. Refer to that as the 2003 Act. So who can make a request? Section 7 of the 2003 Act allows designated prosecutors to make direct requests for assistance, and for courts to issue assistance requests on behalf of non-designated prosecutors. A non-exhaustive list of prosecuting authorities includes the Magistrates' Courts, Crown Courts and the High Court, the Attorney General, the Director of Public Prosecutions, the Director of the Serious Fraud Office, the Environment Agency, the Financial Conduct Authority, and the Secretaries of State for various government departments. Who is not on the list? Local authorities. In trading standards cases such as the Green scenario, the request will need to be made by the court as a designated authority. Whether you are prosecuting or defending, it is necessary to apply to the court for it to request legal assistance. At this stage, I flag that most courts are unfamiliar with the process of making a request, so you should be ready to explain, and for that reason it's sensible to set out in your application a number of things. They include that a criminal investigation or proceedings are underway, the offence is being investigated or prosecuted, a clear description of the evidence sought with an explanation of its relevance and importance, explanation of where the evidence is, the foreign state to be involved, for example, and why the evidence cannot be obtained voluntarily. We also recommend including in your application a draft letter of request, as this will be of great help to the court. There is no official format for such a letter, but it's helpful to include in it, firstly, the name of the designated prosecuting authority, next, details of the key contact responsible for the proceedings, details of the subject of the investigation or the proceedings, a case summary that satisfies Section 7 of the 2003 Act, and there's more to come on that, and outlines the relevant offences which should be annexed to the draft letter. Further details of relevant dates in the proceedings or the investigation, details of the evidence sought, its relevance, its purpose. That's to say, you should show a link between the facts of the case and the evidence sought, details of the person with the evidence or place it can be found, and finally, full details of the assistance sought. The more information you can provide, the better. So when can a request be made? Pursuant to Section 7 of the 2003 Act, before a request for assistance can be made, the designated prosecuting authority, including the court in a trading standards case, will need to be satisfied that, firstly, an offence has been committed, or there are reasonable grounds for suspecting that an offence has been committed. Second, proceedings in respect of the offence have been instituted by the designated prosecuting authority, or that the offence is being investigated. And third, that the request must relate to the obtaining of evidence for use in the proceedings or investigation. If you are defending, the position is slightly different. Pursuant to Section 7 of the 2003 Act, applications for requests for legal assistance can only be made by a defendant after proceedings have been instituted, which means that a defendant has been charged or an information has been laid. If a defendant does decide to make an application, he or she should again be sure that the informal route of obtaining the evidence voluntarily is not available. A common application by the defence is for the court's help to secure the assistance of a witness abroad. In our example, that witness might be the Dutch sales assistant. There is authority in the Crown against Forsyth that the court should allow such an application unless there is good reason not to, which is certainly helpful to the likes of Green Future Solutions in our case. So to whom can a request for assistance be sent? Well, Section 8 of the 2003 Act provides that a request may be sent either to a court in the place where the evidence is situated, in our example, a court in the Netherlands, and that's called direct transmission, and often is used, or more often it's used, that any authority recognised by the government of the country in question as the appropriate authority, that's the other person on whom a request for assistance can be made, the more frequent option. At first blush, direct transmission sounds the more straightforward, but there are plenty of potential difficulties in this approach, including that, first, only a limited number of countries allow direct transmission. Second, it's not possible for certain requests, such as bank account monitoring, to be made, which may be relevant in our Green Future example. For those reasons, direct transmission is not very common and requires particular care to be taken. What types of assistance are available? Well, the range of legal assistance available to the designated prosecuting authority making the request differs from country to country, but generally the assisting country can facilitate the taking of witness statements, conducting of interviews, and giving of evidence on oath. Likely to be of most practical use is the country facilitating the giving of evidence via telephone or video link and executing search warrants and seizure requests. In our example, the banking evidence of Soltec Power Europe or the Dutch agent could be helpful, and the Netherlands could assist in providing this. How can the evidence obtained abroad be used? We come now to Section 9. Section 9 of the 2003 Act concerns the use of evidence gathered through a request for legal assistance. It provides that the evidence may not be used for any purpose other than that specified in the request, without the consent of the assisting authority. So that's yet another reason to make sure your draft letter of request is accurate and comprehensive. Additionally, Section 9 requires that the evidence is returned to the assisting authority when it's no longer needed, unless it is not the type of evidence that can be returned or the authority says it doesn't need to be sent back. Finally, for the avoidance of doubt, the evidence obtained is subject to the same rules on admissibility as evidence obtained in the normal way domestically, so you should be sure that any evidence you request will be admissible in proceedings if you're at that stage before going through the mutual legal assistance process. I now come to the process of serving a defendant outside the jurisdiction. Thus far, we've been considering all things international, and in a moment, Alison is going to talk about the very important issue of getting the right defendant. Briefly, before she does so, what's the process of serving a defendant overseas? Well, that is a process set out in sections 3 and 4 of the 2003 Act. It involves either service by post or the summons and accompanying documents being forwarded via the UK Central Authority, the authority that deals with mutual legal assistance here, to the corresponding authority abroad. In any case where a summons is serviced on a defendant, or indeed a person required to attend as a witness outside the UK, an accompanying notice must be sent that gives the specific information contained in Part 49 of the Criminal Procedure Rules 2015, so be aware of that. Further, where the summons is to be served on a defendant outside the jurisdiction and the prosecuting authority believes the defendant does not understand English, it's really important. You must tell the defendant, tell the court, and provide a translated copy of the documents to be served where possible. I hope this section of the Gough Square Live has helped those who need to obtain evidence from abroad for use in domestic criminal cases, and who perhaps occasionally need to serve defendants outside the jurisdiction. I'll now hand over to Alison to talk through the importance of getting the right defendant and the consent, connivance and neglect provisions.
Thank you, Jack. So Jack has just taken you through summonsing a defendant who is out of the jurisdiction. However, whether the defendant is at home or abroad, once you have identified the defendant and want to summons him or her to court, you will be summoning a person. A person can be an individual or a company, and care needs to be taken with the spelling of the defendant's name. If an individual's name is spelt incorrectly, it can usually be the subject of an application to amend if, despite the incorrect spelling, they have attended court in reply to the summons, knowing it was intended for them. This applies even in circumstances where time limits are an issue, and by the time the matter is before the court, it would be too late to lay new charges. With an individual, it is a misstatement of the name, which can be corrected even out of time. This was established in Crown Investment Limited versus North East Essex Magistrates Court, a case from 2017. The position is not the same with a company, because a company has a specific legal identity. In this scenario, an amendment would be a change to the legal entity and therefore a change to the identity of the defendant. Amending a company name to correct a mistake as to the identity cannot be made out of time. Two examples of charging the wrong legal entity are the case of Marco Croydon Limited versus the Metropolitan Police Commissioner from 1983, where a company hired out skips. One was left unlit on the road and a cyclist hit it and was killed. The skip company was called Marco Croydon Limited, but it traded as A and JB Bull Containers. It's a bit of a mouthful. A prosecution was commenced against A and J Bull Limited, a different company and therefore the wrong defendant. To allow the amendment would have been to substitute an entirely different defendant. The second example is the case of Sainsbury's Supermarkets Limited versus Her Majesty's Court Service from 2006. The information in this case was laid against J Sainsbury's plc, trading as Sainsbury's Supermarket Limited. Whilst the actual company name was similar, neither J Sainsbury's plc nor Sainsbury's Supermarket Limited existed as a company, and the amendment was not permitted. If it is a limited company, double check the name with Companies House, which is a free service. Now moving on to consent, connivance, or being attributable to neglect. The provisions are found in numerous pieces of legislation. For example, Section 239 of the Digital Markets Competition and Consumers Act 2024, which was Regulation 15 under the CPUTs of 2008. And this section says, if an offence under Section 237 committed by a body corporate is proved A, to have been committed with the consent or connivance of an officer of the body, or B, to be attributable to any neglect on the part of an officer, the officer as well as the body corporate is guilty of the offence and liable to be proceeded against and punished accordingly. Subsection 9 says, in subsection 5, a reference to an officer of a body corporate includes reference to A, a director, manager, secretary, or other similar officer, or B, a person purporting to act as a director, manager, secretary, or other similar officer. Further examples of these provisions are found in Section 40 of the Consumer Protection Act of 1987, Section 36 of the Food Safety Act 1990, Section 101 of the Trademarks Act 1994, but note only for consent or connivance, and Section 12 of the Fraud Act 2006, and again, only consent or connivance is available. An officer is either a director or the company secretary. However, as we have seen, the provision extends by virtue of Section 2399 to a manager, etc. This person must really be a part of the directing mind of the company. In the case of the Queen versus Bowl, a general manager was charged under Section 23 of the Fire Precautions Act in 1971. And the court said, the intended scope of Section 23 is, we accept, to fix with criminal liability only those who are in a position of real authority, the decision makers within the company, who have both the power and responsibility to decide corporate policy and strategy. It is to catch those responsible for putting proper procedures in place. It is not meant to strike at underlings. The principles for consent, connivance and neglect have developed from case law over the years. The 1970s saw the first real assessment in this area in the well-known case of Huckabee and Elliott from 1970. This case concerned a club which had to have a license to run card games. The club did not have the requisite license. Certain directors were charged by the consent or connivance and pleaded guilty. But a further director, Huckabee, was charged by her neglect. She had no knowledge of the fact that the club had not obtained the necessary license, although she knew that money had been put aside for this purpose. Although she was a director, she knew very little about the conduct of the club. Another director, the club secretary, was fully acquainted with the business and far better placed to take responsibility. And Huckabee had no reason to mistrust his actions. Mr. Justice Ashworth stated that Huckabee knew that the obtaining of a licence had received the attention of the company, but it would be wrong to say that she was neglecting her duties if she failed to make a specific inquiry whether a licence had been obtained. The principles from Huckabee are therefore consent. The director consents to a commission of an offence by his company. He is well aware of what is going on and agrees to it, so knowledge is needed. Connivance. He is equally well aware of what is going on, but his agreement is tacit and not actively encouraging what happens, but letting it continue. Neglect is not failure to see that the law is observed, but rather the prosecution has to show that the director was guilty of any neglect to do what they ought to have done. And that's a very important point, that ought to have done, or what they ought to have done. As a general observation, when looking at delegation, where a company has multiple directors, there is no duty on a director to supervise the other directors or acquaint himself with all the details of running the company. It is perfectly proper to leave matters to another director, and there's no obligation to test the accuracy of anything you're told by another director, unless there is a reason to mistrust another director. The case of Hirschler versus Birch from 1987 was a case where Director 1, who was the defendant, wanted to import brake lights into the UK from Holland. He was warned that the brake lights were no longer lawful. A fellow director, Director 2, was charged with carrying out inquiries to establish if they were legal and was told by Director 1 that he was not sure about the lights. Director 1 was then told the lights were legal by Director 2, but he did not ascertain what inquiries had been made, and it transpired that Director 2 had not made diligent inquiries. Director 1 was convicted by his neglect in that he had failed to ensure an authoritative answer to the issue. He appealed on the basis he delegated responsibility to Director 2 and was entitled to rely on that delegation. The conviction was upheld on the basis that he did not do what he should have done or ought to have done in spite of the measure of delegation. He was on notice as to the question of the legality of the lights, but he simply accepted what Director 2 told him. A further case, the Crown versus P from 2007, was a health and safety case involving an accident at the docks where a 6-year-old boy was killed after being thrown from a forklift truck in a practice that was apparently commonplace at the docks. Lord Justice Latham observed, "The question at the end of the day will always be where there is no actual knowledge of the state of facts, whether nonetheless that an officer in question of the company should have, by reason of the surrounding circumstances, been put on inquiry so as to require him to have taken steps to determine whether or not the appropriate safety procedures were in place. In the well-known case of R versus Shargo Limited, trading as contract services and others, from 2008, another health and safety case, where a driver was killed while driving a dumper truck on a building site. The principle, if a director is at the coalface, then less evidence might be needed than a director who works remotely from the workplace. It was said that consent can be established by inference as well as by proof of express agreement. That was Lord Hoffman. Further, Lord Hoffman said, where it is shown that the body corporate failed to achieve or prevent the result that those sections contemplate, the sections of the Health and Safety Act, it will be a relatively short step for the inference to be drawn that there was connivance or neglect on his part, if the circumstances under which the risk arose were under the director or control of the officer. The more remote his area of responsibility is from the circumstances, the harder it will be to draw that inference. Whilst there are other cases that look at these principles, and the last case I'm going to talk to you about is R versus Hutchins and Charalambos from 2011. In that case, the two directors knew that unlicensed guards were being deployed, but did not have knowledge of specific deployment of an individual employee in a particular or specific role. What had to be proved was that the directors knew that unlicensed guards were being or would be used by the company, and that they had agreed to the company's conduct of its business on the basis of those facts. There was a memo which clearly showed that both directors had full knowledge that at the date on which all guards had to be licensed, that the company would continue to deploy guards whose applications were still being processed, so therefore not licensed. The prosecution did not have to prove that the directors knew of each individual specific offence that might be committed, and it was impossible to say on the facts that Hutchins had not consented to, or at least connived in the deployment of unlicensed guards. If that did have to be proved, that would allow directors to shut their eyes to the management of companies. So in conclusion, whilst not duplicitous to lay a charge including all three aspects, that is consent, connivance and or neglect, where obvious, then the colours should be nailed to the mast. If there is a question mark over knowledge, then only neglect should be considered. It can make quite an impact, however, when sentencing consent or connivance versus neglect. If matters are left solely to one director, then this is sufficient to absolve other directors from liability, as we've seen from some of the case law. However, Motor Depot Limited versus Kingston upon Hull City Council from 2012 had an important quote by Lord Justice Elias. It was a proper inference that, in a company of this kind, for somebody who was treated as the boss and claimed to be managing director, and where the advertisements were so central to the business, there would be a duty on the managing director. Of course, that only raises what is in effect a prima facie case, which then is capable of being rebutted by the defendant going into the witness box and demonstrating that in fact there was somebody else who was responsible and that there was no reason to suppose that he should be supervising the activities of that other person. And that's the quote by Lord Justice Hoffman from the case. As can be seen, therefore, much turns on the circumstances of each individual case, and this will need to be examined in every instance.
Well, thanks very much, Alison. We really hope you've enjoyed this episode of Gough Square Live.
And we do hope that you'll join us for the next episode on the 2nd of September of this year. And from Jack Brady, it's
goodbye.
And goodbye from me as well.